Welcome to SQE One Window, another one, Chapter 12 of Dispute Resolution, and we will be talking about interim applications. We'll try to understand the role, process, and the purpose of interim application in civil litigation. So, right, let's start with the basics. So, now imagine litigation is a very long process, winding road trip. An interim application is like stopping at a service station, not the destination, but absolutely necessary to keep journey going. Like you need something in the middle of your litigation. So interim application are made during the proceeding before trial when one party needs the court to decide something, maybe to extend a deadline, freeze someone's asset, or strike out part of claim. They can range from utterly mundane, like kind of very simple, such as please can we have 2 or more weeks to file a witness statement, to the dramatic, your honor, we need an injunction to stop them from selling the house. But every interim application must align with the overriding objectives. In civil litigation, we have talked about it. That means helping the court deal with the case justly, proportionately, and effectively, and with reasonable cost. That we have talked a lot. If your application wastes everyone's time, the judge will not be impressed, and neither will your client when they get the cost bill. So when you think of interim application, think of them as strategic tool, not tantrums. They are not there to annoy the other side, though some solicitor do get suspiciously creative in that area. You cannot convince them, confuse them. So this kind of things. So before making an application, you have to advise your client properly. That means explaining 3 things clearly. First, the purpose. Why are we applying? Second, the risk and costs, because nothing is in litigation comes for free. And third, the likely outcome, including what happens if we lose. You must get informed instruction, no surprise later. There is nothing worse than a client saying, I never agreed to that, halfway through a hearing. So at that point, it will be a big embarrassment for you. And in some cases, there can be an SRA vigilance against you. Now, how are applications decided? Well, they can be determined either on paper or at a hearing. A paper determination means the judge reads the application, the written evidence, and decides without a hearing sometimes. It is perfect for straightforward issues or when you would rather not risk talking yourself out of a win. So you need to understand that a hearing, on the other hand, can be in person, by phone, or video link. They use it sometimes. Modern litigation loves a good Zoom hearing. All after COVID, like you can see that this is new normal. Although occasionally some still forget they are on mute. Yeah, you can see people while passionately arguing their case. So be careful with the technology. So in short, the method depends on the nature of issue, the urgency, the judge's preference, which, let's be honest, is the only preference that truly matters, what judge wants. Okay. The next thing is, now let's talk about like common procedure and services, and this is where application really matters. Application are governed by CPR Part 23, Practice Direction 23A. You use form N244. Sometimes they ask this kind of things, which form we'll use here, but not most of the time. File it with the court and pay the fee. Yes, there is a fee you need to pay for interim application. Nothing is a free lunch. So next, you must serve the application notice and evidence at least 3 to 5 days before the hearing. Clear days mean you exclude the day of service and the day of hearing. Classic trap of unwary, like people don't exclude the days and they don't know what is clear day. Clear day mean 1 complete day. The respondent should then file their evidence at least 2 days before the hearing, and a cost schedule form, that is N260, at least 24 hours in advance they need to file it. It is like a formal dance, the CPR choreography, miss a step and you may find the court saying, "Thank you, counsel," but that was not quite the routine we expected at that point. So get your timing, paperwork, and service right. Everything is in order, and that's a good practice, and you survive. Another thing is like application with and without notice. Sometimes, in some cases, we need something from the court, interim order, without telling the other party, without giving notice. So application without notice. Most interim application are with notice, meaning the other side is informed and both parties have the opportunity to be heard. It is the legal version of fair play, like something we take quite seriously in English courts. However, without notice application are allowed only in limited situations. There are certain situations where it is allowed, but those are very rare. So when there is a real urgency, say you need to freeze assets before they disappear, when both parties consent, or when rules or court specifically allow it. But here is the catch: if you make an application without notice, you must explain why you did not give notice. The judge must be satisfied that it was justified. If the court later decides your urgent reason was more fiction than fact, you could face wasted cost. Basically, the court's polite way of saying you have wasted our time, now pay for it. So, use without notice application sparingly, like, you should not use them. They are powerful tools, but also potentially explosive, much like reheating fish in the office microwave, and everything goes bad. So, another thing is, unless notice and relief from sanction, it is examined on many occasions, and you will find it this kind of like I found it in my SQE question set. Now let's talk about what happens when things go wrong, because in litigation they often do. If a party fails to comply with the rule or order, the court may issue a unless order. It is a clear warning: comply by this date or face the consequence of. If the deadline is missed, the sanction applies automatically. Often strikeout or dismissal, the only lifeline then is an application for relief from sanction under CPR 3.9. The leading case is Denton case, which gives us 3 stages: assess the seriousness or significance of the breach, consider why default occurred, and evaluate all circumstances so the case is dealt with justly in just form. So, the key idea is proportionality. A minor delay might be forgiven, but unreasonable delay will not be. So, what can be the consequences? It can be default judgment, summary judgment, interim payment, or security of cost. For SQE, I would say before we wrap up, you need to be careful. First, remember that the exam loves to test application timing and notice requirement. And also, what will happen if there is a breach? They will give you a scenario. The solicitor applies urgently without serving notice, and you must spot whether that was permissible or not in that case. Second, know your Denton test for relief from sanction. If something has gone wrong, what can be what can be an idea that can save you? The examiner adores it, like, they adore this kind of things. And missing a step in the test is like leaving milk out of your tea. Unforgivable. Third, always think your answer back to the overriding objectives. It shows your understanding, like, that how courts work, not just rules. Like, you need to understand broader principle overriding objectives. And finally, avoid common traps: forgetting to serve document within the right time frame, ignoring procedural fairness, and without notice application, like, misunderstanding cost consequences. In short, think like a solicitor: practical, precise, and prepared. The exam is not testing whether you have memorized the rules, as I talk about different rules, but whether you understand how to apply them sensibly as a real lawyer. So if you can do that and maybe keep a straight face while reading the question about urgent injunction at 5 p.m. on a Friday, you will be just fine, that we need it or not. So that brings us to the end of chapter 12, interim application. We tried to look at why they are needed in the journey, why clients need certain relief once the case or litigation is not concluded. I hope it makes sense. I'll see you with the next chapter and most important area where you will be examined. That is part 36 of our. So thank you very much for joining us. Ta-da!